We are from Pugree Tenants Action Committee. Thank you for coming here. We are waiting for Shri Narwekar to come. In the meanwhile, I would appreciate if there are empty chairs in between, if you can just occupy them so that people in the aisle can access the empty chairs from there. And if there are old people who are standing later, I would appreciate if the young ones stand up and let the old people sit down. So just bear with us for some more time. We are waiting for Mr. Narwekar to come and then we start the proceedings. Thank you. Dear tenants, we have been told that the Narwekar Brandhu are coming or on their way. But in the meanwhile, I thought since most of you have been anxious enough to be here by 5 o'clock instead of 5:30, we would talk a little bit more about what's facing us and things that most of you we have figured out that a lot of people don't know what is happening according to the Rent Act or most people I realize are not aware of what is happening. In the meanwhile, I would like Mr. Sapre. Mr. Sapre, can you come up please on the stage? Reshma, just help him so that he doesn't trip over that. So Mr. Sapre has been an activist for the last 30 years. He basically engages with all public sector unit tenants and tenant issues. When I say public sector, it is LIC, general insurance, nationalized banks and railways, etc. So he has been working on these issues with these, and BPT. BPT also, Mr. Sapre, right? Okay. So, so these are lots of bugbears within under Rent Act. So Rent Act is like one huge bird and you have little fledglings under it, which depending upon who the landlords are. So, and each one of them have a different set of issues and considerations. So, Mr. Sapre manages and has been on his own expense been fighting this case for the last 35 years. I would like to call upon Mr. Prerak Chaudhary, who's an advocate, practicing advocate in High Court, Mumbai High Court, and he is known to be an advocate for the tenants. And ह्याचा आवाज का कमी झाला? बरोबर आहे? Please give him a big hand. Mr. Chaudhary has been there for tenants for several years now and he's been practicing in the High Court. Today he also will be explaining to you what is happening in the Supreme Court matter. We also have with us Mr. Yash Merchant. Yash Momaya. Sorry, slip of my tongue. He's advocate High Court and has been active in this matter for the last 10-15 years. I also would like to thank, though Utsal is not coming up on the stage, Utsal Karani sitting here has been very, very instrumental in this whole Supreme Court and Bombay High Court cases since 1992. It's his association for tenants, JVPD Residents and Tenants Association, which is the intervener in the Supreme Court in our matter right now. So we are, in the last 3-4 months, ever since this 9-judge bench has been announced, Mr. Karani has been running pillar to post to ensure that everything is correct and perfect where his committee is concerned, so that we can still continue to be an intervener. So please give him a big hand. Thank you, Utsal. I can see many known faces also who have been with us for the last 9-10 years that we started this Pugree Tenants Action Committee. It all started in 2015 actually, when Mr. Prakash Mehta was the housing minister of Maharashtra, and he came up with a draft housing plan. I don't know how many of you remember this or have been part of our committee members since then. I mean, part of our tenant groups since then. But we had a huge organized I think Chandrasekhar Prabhu had organized it in Sachivalay, and we organized something in the BCA also, um, where we told the government that you cannot separate tenants according to their incomes or according to the size of their flats, which is what the draft housing policy wanted to do. Because the moment the housing policy would have achieved that, they would have then said, okay, so Rent Act is no longer fully applicable, and then the rest of the people who are living in smaller flats or smaller homes would then also face the acts according to legal judgments. Because if the Rent Act was taken out of purview for larger flats, then over a period of time, the same argument can be used by the property owners for smaller flats. So we fought that case in 2015, and the government then decided not to go ahead with it. Then again in January 2016, the central government this time came up with a Model Rent Act. Sorry? You can't hear me? Okay. Is this good? Okay. So in 2016 January, you had another attempt at changing or maybe demolishing the Rent Act completely in the form of Model Rent Act, which the government of which the Union Ministry of Housing came up with, and it was essential for every state, however, to pass this particular act. So we again wrote a lot of letters, and we got all our tenant community from the 7 Pugree tenant groups that we have on WhatsApp. We got them to write emails to the Union Ministry of Housing, and then we scuttled that particular try of this government to stop the Rent Control Act once again. So there have been many instances in the past few years where Rent Control Act has been attacked, so to say. I mean, attacked, or it's too harsh a word maybe, but people are trying to undermine the impact of Rent Control Act, and it is very, very worrying right now what is happening, which of course Prerak will talk about. I just wanted to tell you guys also about what we are. We have gotten together in 2015 to form this action committee, and we fought these 2 cases. आणि भाडेकरूंचे आम्ही एकटेच आहोत असे नाही. We are not the only people who represent tenants. There are many more, I'm sure, but we have been very, very active and trying to use people whom we know to get to meet people who decide. So there are a lot of us here, and thank you for that. And I must tell you all that in all these years, we have never asked anybody for any money. We have never raised a single naya paisa, and we have done everything on our own. I would like to take this opportunity today to also ask you for help in this matter, because now we will have to pay the councils involved in the Supreme Court matter. I will be passing on the information, and you can pay JVPD directly, and we will be sending information as to whom the payments have come from and whom the payments will be going to. So there is complete transparency. I mean, none of us are in a situation where we need to gyp anybody of any money, and we would like to keep our noses and heads up and noses clean. So please trust us in this, that the money will be going only to the councils who will be working on our behalf in the Supreme Court matter. I shall be posting the details of the bank account, etc. in our chats tomorrow. Now to come about Pagri system, Prerak, would you like to talk about it? What is Pagri? You can, we both will talk. मराठीत पण बोलू का? हे सर्व मराठीत परत सांगू का तुम्हाला? हिंदी में?
ठीक है,
अच्छा,
विल यूज़ इंग्लिश, विल हिंदी, हाँ ठीक है, हिंदी में बात कर लेंगे। लेकिन जो लीगल चीज़ें आती है वो समहाउ सबकॉन्शियसली हम लोगों के इंग्लिश में चलती है, क्योंकि हमारे कोर्ट की भाषा इंग्लिश है। तो कभी हम लोग इंग्लिश का प्रयोग करें तो हमें उसके लिए माफ़ करिएगा। सभी टेनेंट ब्रदर्स एंड सिस्टर्स को नमस्कार। विदुला जी, रेशमा जी, महेंद्र जी, यश के पापा नयन जी, चंद्रशेखर जी, पुरोहित जी, नार्वेकर जी, हमारे टेनेंट कॉज के लिए लड़ने वाले इतने लोगों की सूची है कि मैं सबका नाम नहीं ले सकता। और ख़ास करके यहाँ पर आए हुए हर आदमी एक तरीके से एक एक्टिविस्ट है, क्योंकि ये इशू 30 लाख जो है ऑफिशियली जिसको हम लोग डॉक्यूमेंट कर सकते हैं, और ऐसे लोग कहें कि इनडायरेक्टली 2 करोड़ लोग से ज़्यादा जो इशू प्रभावित करता है, वो इशू को हम लोग यहाँ पर डिस्कस कर रहे हैं। और हम हैंडफुल लोग हैं जो, मैं श्योर हूँ कि every person sitting here represents a building or translates to at least 100 other tenants. And the issue is so important that at such a short notice, at just a WhatsApp message circulated by Vidula, this is the response that has come, and which is, we expect a much larger gathering eventually. And you all would be sad to see that the state in which the matter stands today is that written submissions were to be filed by our state by December. They have not yet been filed. Having said that, I'm not saying that our state is not doing enough to protect the Rent Act. I'm thankful to our state because we have the most robust Rent Act. I'm proud that our state of Maharashtra is the state which has, if I may dare say so, led the rent revolution in the country. But now, when the matter is before the 9-judge bench of the Supreme Court, आज जब ये मसला सुप्रीम कोर्ट की 9 जजों के सामने है, और क्वेश्चन ये है कि ये रेंट एक्ट की संवैधानिकता को कसौटी पर कसा जाएगा, ये रेंट एक्ट स्टैंड करेगा कि नहीं, जो रेंट एक्ट हम लोगों के घरों का आधार है, आज ये बात हमारे घरों पर बनाई है। तो ये हमारी ड्यूटी है कि इसके अंदर जो भी योगदान हम कर सकते हैं हमें करना चाहिए। Thankfully, Pugree Tenants Action Committee or even any other activist for that matter who I know, कोई भी धन के योगदान की बात नहीं कर रहा, लेकिन कम से कम हमें सबको सचेत रहना है। और जब डेमोक्रेसी में हम रहते हैं, नंबर्स यहाँ पर बहुत इम्पॉर्टेंट है। तो हमारे नंबर्स जब दिखते हैं तो हमारे जो इलेक्टेड रिप्रेजेंटेटिव्स हैं वो इस इशू की गहराई, इसकी सेंसिटिविटी, इसकी नज़ाकत को समझेंगे। और हमारे ये आज की मीटिंग के अंदर में सबसे मोस्ट इम्पॉर्टेंट इमीडिएट इशू, ऐसे तो हम लोगों के बहुत सारी मांगे हैं, मैं चाहता हूँ कि टेनेंट्स को टेनेंसी राइट्स के अंदर में और इजाफा आए। टेनेंसी के अंदर में कई राइट्स है, जैसे आज हमें लैंडलॉर्ड पे डिपेंड करना पड़ता है, हम ट्रांसफ़र करना चाहें हम कर नहीं सकते हैं, तो हमें एक राइट टू ट्रांसफ़र ऑन सम डिसाइडेड अमाउंट या एक SOP उसके ऊपर बननी चाहिए। टेनेंसी राइट्स के ऊपर आज फाइनेंस नहीं कोई अवेल कर सकता है, टेनेंसी को विल नहीं कर सकता है। तो ऐसे तो दिल की पूछें तो बहुत सारी टेनेंट्स की मांगे हैं जो हमें आगे लेना चाहिए। लेकिन जो इस समय का इमीडिएट इशू है, जो लोएस्ट हैंगिंग फ्रूट है, जिसको हमें पहले तोड़ना है, वो ये है कि जो सुप्रीम कोर्ट के अंदर में आज रेंट एक्ट इटसेल्फ खतरे में पड़ा है, वो रेंट एक्ट को डिफेंड करने के लिए हमारा स्टेट ऑफ महाराष्ट्र सबसे जो भी मोस्ट एबल काउंसिल महाराष्ट्र सरकार की तरफ से केस लड़ते हैं, उनको जो ब्रीफिंग मिलनी चाहिए वो परफेक्ट ब्रीफिंग मिलनी चाहिए, उनके पास सब डॉक्यूमेंट्स पहुंचने चाहिए, और स्टेट को जो भी रिप्लाई फाइल करनी है, रिस्पॉन्स फाइल करनी है, रिटन सबमिशंस फाइल करने हैं, अच्छे से अच्छे काउंसिल्स की सहायता के साथ सुप्रीम कोर्ट में इस मैटर को लड़ना है। तो उसके लिए हम लोग सब, राहुल जी आज हमारे बीच में रहेंगे कुछ समय के अंदर में, जो अध्यक्ष हैं हमारे विधान सभा के महाराष्ट्र स्टेट के, तो वो हमारे बीच रहेंगे। उनसे ये निवेदन रहेगा कि इस इशू को आप थोड़ा सा और सीरियसली परस्यू करने के लिए स्टेट गवर्नमेंट को बोलिए, जिससे कि हम भाड़ूतों की अधिकारों को और बल मिल सके और हम लोग और सशक्त हो सके। तो इसी अभी रेंट एक्ट के ऊपर में एक ब्रीफ बैकग्राउंड आपको देना था कि हाउ दिस हैज़ रीच द 9 जज बेंच. कोई बोलेगा ये तो छोटी सी इशू है, ये 9 जज के बेंच के पास ये कैसे पहुंच गया है मामला. तो ये इसलिए पहुंच गया है क्योंकि 9 जज की बेंच ये डिसाइड करेगी कि जो रिसोर्सेज है, जो स्टेट की रिसोर्सेज है, क्या प्राइवेट प्रॉपर्टी वो स्टेट की रिसोर्सेज में पब्लिक वेलफेयर के लिए यूज़ की जा सकती है कि नहीं. रेंट एक्ट जैसे कि आप जानते हैं, रेंट में एक प्राइवेट प्रॉपर्टी है जिससे एक पब्लिक पर्पस सेटिस्फाई होता है. तो ऐसे ये एक विषय, एक संवैधानिक विषय है जो सुप्रीम कोर्ट की 9 जज की बेंच के सामने है. क्योंकि मफतलाल के केस के अंदर में संजीव कोक को रेफ़र किया था और क्योंकि मफतलाल का केस 9 जज की बेंच ने डिसाइड किया था, इसलिए इस इशू को डिसाइड करने के लिए 9 जज की बेंच का गठन हुआ है. द केस हैज़ बीन referred to a 9 judge bench of the Supreme Court because the Mafatlal case, which referred to the Sanjeev Coke case, was decided by a 9 judge bench. Therefore, a 9 judge bench is required to be constituted to deal with this issue. So it's a constitutional issue. At the same time, this has been tagged along with the 100 months rent issue, where chapter 8A of Mahada, which says that contemplated that you could pay 100 months rent and take over the premises from the landlord. That also has been challenged, and both these issues have been tagged along together. And a lot of people have filed their representations and responses, including the Property Owners Association, which is the opposite party. So everybody but for Maharashtra State has filed their written representations, their written submissions before the Supreme Court. So we request Rahul ji, when he comes, and the request has to come from the house here, to coax the state government to do the needful in the matter.
To add to what Prerak just said, I'm not standing up, I'm just sitting and chatting with you guys. To add to what Prerak just mentioned, in the government, the way the government deals with pagri system is it treats the pagri person as the pagri tenant as a quasi owner. In its various taxation systems, for example, a pagri tenant has to pay property tax. No other tenant pays property tax. So the genesis of the pagri system was till early 1960s. We had no Cooperative Housing Society Act till the early 1960s. So before 60s, in any urban area of Maharashtra and Bombay Presidency in those days, which is Gujarat and Maharashtra today, if you wanted to live in urban city, जर तुम्हाला एखाद्या शहरामध्ये राहावं लागत असे तर तुम्ही जागा विकत घ्या आणि त्याच्यावर घर बांधा. You had to buy the land and build your own home. नाही तर a landlord who already has a home could part with part of his house to you, and because the taxes were so high, we had calculated once that wealth tax, capital gains tax and income tax all together was 107%. So nobody wanted to show this sale deed. So pagri was taken at market rate as compensation, but the person had to pay a very minimal rent because it came under Bombay Rent Act. Bombay Rent Act was passed in 1947. So why, from 47 to 62, a landlord would not be stupid to be parting with his house at such piddly rents. मला म्हणायचं आहे काय की 1947 मध्ये मुंबई रेंट ॲक्ट जेव्हा फ्रीज झाले, बॉम्बे रेंट ॲक्टनी फ्रीज केले रेंट्स, तेव्हापासून कोऑपरेटिव्ह हाऊसिंग सोसायटी ॲक्ट येईपर्यंत 20 वर्षांमध्ये घरमालकांनी घरं कॅशमध्ये विकली आणि आपल्याकडे काही कागदपत्र नव्हती कारण त्यांना थोडा टॅक्स भरायचा नव्हता त्याच्यावरती. त्यामुळे 107% टॅक्स पडायचा त्यांना. त्यामुळे ते सगळं कॅशमध्ये असायचं ट्रान्झॅक्शन. म्हणून माझी पगडी तुझ्या हातात, म्हणून त्याला पगडी टेनन्सी म्हणायचे. आणि आणि तुम्हाला फार कमी भाडं कारण रेंट ॲक्टमुळे आपल्याला भाडं वाढवता येत नसे, तर त्या भाड्यावरती तुम्ही राहावं लागत असे तिकडे. आणि प्रॉपर्टी टॅक्सेस तुम्हाला भरावे लागत असत, कारण तुम्ही ओनर होता. ओनर असल्याशिवाय प्रॉपर्टी टॅक्स कोणी भरत नाही. Property taxes are expected from Pugree tenants because we are quasi owners of the place, though do not have any paperwork to support this. You also had to pay water cesses. So if you go back to your early rent receipts, those of you who have the paperwork, you will see standard rent, then you would see property taxes, and then you would see water cess. This is how the receipts were given by the landlords in the early eras. So what happened after that was then this Pugree tenancy therefore became entrenched in Mumbai, mostly island city. But also we found, after we started this, we found that we have people in Ghatkopar, Sayan, Virar, Vasai, Palghar, Thane, parts of the Shukravar Pet and the Budhwar Pets of Pune. Ravivar Karanja area in Nashik, Kolhapur, as Prerak just said, Bhayandar. We have people here, I think Vipul has come from, there he is. He's come from Santa Cruz, Vakola, Khar, all these areas, there was Pugree tenancy and there still is Pugree tenancy, because anything built before 1962 was on Pugree. Actually, Pugree people are the people who have made Mumbai what it is today. It is us who lived in this city and created what this city and its, as they say, spirit of Mumbai. And so today, though we don't have the papers, in 1999, when the government codified all the various rent acts and made the Maharashtra Rent Control Act, it actually said that Pugree was paid. And since then, the people who have bought Pugree flats have actually paid stamp duty on the transaction, and they have been duly registered. So you have now a codified way in which you can prove that you are a Pugree tenant, where you have actually paid. So the person who bought the Pugree flat paid 2/3 normally to the outgoing tenant and 1/3 to. Okay. I would like to welcome Shri Narwekar. The flowers. Yeah. No problem. We were just. We were just explaining to them the genesis of this whole thing. And so to just add a couple more things, in the taxation system in today's India, we pay property taxes, we pay stamp duty to the state government, and when I'm selling a Pugree property, I am liable to pay capital gains tax also. So as a Pugree owner, I'm treated by Indian taxation and legal system as a owner of the property. I'm not a squatter. All of you must recognize this. We are not squatters. We are people who have paid the market rate when the flat went on Pugree. You might not be the original tenant, but whoever the original tenant was, you might be a person who's come in later. And so therefore, the landlord has made the original amount of money. Okay, and every time the hands have changed, the flat has changed hands, the landlord makes 33 to 40% of the market rate once again. So they cannot say that we are getting measly rents. They are getting money much more than what any other person who sells property does, because it's a continuous income stream that they are having. So that is their contention in the Supreme Court. That's why I wanted to delineate this specifically. Their contention is that measly rents, we do not get anything out of this. That's why remove rent control. So I will not take more of your time. I just wanted to explain this particular point to all of us here assembled, that please do not feel that we are any lesser mortals because we have paid pagri, or whoever the original tenant was had paid compensation to the landlord at that particular moment in time, at that market rate. And with that, I will again give the mic to Prerak.
राहुल जी हमारे बीच में है, उनका बहुत बहुत स्वागत। Rahul ji, these everyone, all of us who have collected here want to save our Rent Act, and we request you to help us doing that. The issue is before the Supreme Court, before a bench of 9 judges. It's likely to be taken up in April. We request you to get the state government to put up the best possible fight, the fiercest possible fight, if I may say so that our Rent Act is protected and it's not struck down as unconstitutional. Sir, the short background of what has happened is that, and I know that I need not brief you because you are already aware of the whole controversy, but after the Bombay Rent Act of 1947 got struck down in, was declared unconstitutional in Malpe Acharya's case, and our state government enacted a new Rent Act, that is the Model Rent Act of 1999. After that, because of a series of different challenges, the matter has finally reached the Supreme Court's 9-judge bench. And the 9-judge bench has been constituted because of a constitutional issue that the Supreme Court is now going to evaluate whether material resources belonging to the society include private property. They would also look into Article 31C, whether it stays or it doesn't stay. So there are these different constitutional issues, but what affects us the most, and to keep it very simple for layman, हमें खाली एक चीज़ से मतलब है सर कि हमारा रेंट एक्ट जो है वो स्ट्राइक डाउन नहीं होना चाहिए, क्योंकि वो हम लोगों का आधार है, हम लोग सब उसके अंदर में ही, वो एक पेड़ है जिसकी छत्र छाया में हम सब हैं, तो वो पेड़ को किसी को काटने मत दीजिए बस, विदाउट, बिकॉज एवरीबडी इज़ वेटिंग फॉर टू हियर यू, without taking much time. If Yash would want 100 months rent issue, as Rahul ji is already aware, महाड़ा के चैप्टर 8A के हिसाब से 100 months का एक रूल आया था कि टेनेंट्स को एक ओनर बनने का, एक ओनरशिप देने का एक एनेबलिंग प्रोविजन था, वो भी आज संकट में है. Even that's before the Supreme Court. So on all these issues, and we can go on and on, but if Sapreji and Yash would want to add something.
I think Prerak has very capably given you all the background and the overview of the matter. I only want to add a couple of things. Number one, I think we should all keep in mind that what is at stake is the constitutional validity of the Rent Act, by which I mean, if the Supreme Court strikes down the Rent Act, which is what the Property Owners Association has gone to court for, and when we say strike down, we mean the court says this is unconstitutional. The effect of that is there will be no rent control in Maharashtra. मैं हिंदी में बोलूँगा सर. There will be no rent control in Maharashtra, and if there is no rent control in Maharashtra, all of you, your homes and your offices and your shops and your commercial premises will all then not be protected by the Act, and you will all be liable to be evicted. So the stakes are very high, but we have full faith in our state government, and with Mr. Narwekar's intervention, we have full faith in our state government to defend the Act before the Supreme Court and to protect the interests of tenants. Sir, मैं हिंदी में बोलूँगा एक बार आपके लिए. मैटर सुप्रीम कोर्ट में ये है, एक लाइन में मैं बोल सकता हूँ. प्रॉपर्टी ओनर्स एसोसिएशन, जो लैंडलॉर्ड का एसोसिएशन है, उन्होंने सुप्रीम कोर्ट में केस फाइल किया है जिसमें उनका प्रेयर है कि महाराष्ट्र रेंट कंट्रोल एक्ट को अनकॉन्स्टिट्यूशनल डिक्लेयर करो. अगर सुप्रीम कोर्ट ये मानता है और लैंडलॉर्ड के फेवर में फैसला देता है, उसका मीनिंग है कि रेंट कंट्रोल महाराष्ट्र में नहीं बचेगा और आप लोगों के घर और ऑफिस विल बी एट रिस्क. Therefore, the matter is very serious, and therefore we humbly request Mr. Narwekar's intervention.
Mr. Sapre, would you like to talk about Public Premises Act under Rent Act, please?
Thank you, Rahul ji, for being here with us. Thank you, Vidula ji, for organizing this meeting. And of course, I have been dealing with his father for the last almost 2-3 decades. Now, there are some कुछ गलत फहमियाँ हैं. मुंबई में और महाराष्ट्र में 2 किस्म के टेनेंट्स हैं. एक टेनेंट ऐसे जिनके लैंडलॉर्ड प्राइवेट लैंडलॉर्ड है और दूसरे टेनेंट्स हैं जिनके लैंडलॉर्ड LIC, नेशनलाइज्ड बैंक्स, रेलवेज, नेशनल टेक्सटाइल कॉरपोरेशन, तो जितने पब्लिक सेक्टर्स हैं उनके भी टेनेंट्स हैं. तो एक गलत फहमी थी कि ये सब टेनेंट जो पब्लिक सेक्टर के हैं वो पब्लिक प्रीमाइसेस इविक्शन एक्ट के अंडर आते हैं. लेकिन ये गलत फहमी है क्योंकि 80% जो टेनेंट्स है पब्लिक सेक्टर के वो दे आर गवर्न सोनली बाय रेंट कंट्रोल एक्ट एंड नॉट पब्लिक प्रीमाइसेस इविक्शन एक्ट. सो एनी प्रोसीडिंग्स अंडर पब्लिक प्रीमाइसेस एक्ट विल बी नल एंड वॉइड. तो आज मैं इसलिए यहाँ पर आया हूँ. राहुल जी, आपने when you addressed LIC tenants recently, you mentioned about Public Premises Act and Maharashtra Rent Control Act. Now, 80% of the PSU public sector tenants, they are governed by only Maharashtra Rent Control Act. And Public Premises Act is not applicable. So, naturally, all the public sector tenants जो बॉम्बे में रहते हैं वो भी रेंट एक्ट के अंडर आते हैं. तो हमें भी ये फिक्र पड़ी है कि रेंट एक्ट का क्या होगा. तो ये ज़रूरी है कि रेंट एक्ट को कैसे भी करके प्रोटेक्ट करना चाहिए. तो इसलिए मैं राहुल जी को बोलने वाला था कि पब्लिक प्रीमाइसेस एक्ट डज नॉट सुपरसीड महाराष्ट्र रेंट कंट्रोल एक्ट. उसमें इतना फ़र्क है कि जो टेनेंसीज, जो पब्लिक प्रीमाइसेस के जो टेनेंसीज बिफोर द टेनेंसी बिकेम पब्लिक प्रीमाइसेस, द प्रीमाइसेस बिकेम पब्लिक प्रीमाइसेस, उसके पहले जो टेनेंसी थी वो सोनली महाराष्ट्र रेंट कंट्रोल एक्ट से कंट्रोल होती है. दे आर गवर्न बाय महाराष्ट्र रेंट कंट्रोल एक्ट. टेनेंसीज created after premises became public premises, those tenants are governed by both the acts, Maharashtra Rent Control Act and also Public Premises Eviction Act. तो जो Public Premises Act का बहुत लिमिटेड पर्पज़ है, जो अनऑथराइज्ड ऑक्यूपेंट को निकालना. अगर ओवरस्टे उन्होंने किया तो रिकवरी ऑफ एरियर्स. बियॉन्ड दैट पब्लिक प्रीमाइसेस एक्ट को कोई भी राइट्स नहीं है. बाकी जितने इश्यूज है, fixation of rent, transmission of tenancy to legal heirs, so various issues, ये सब issues रेंट कंट्रोल एक्ट के अंडर आते हैं. तो पब्लिक प्रीमाइसेस के टेनेंट्स भी पब्लिक प्रीमाइसेस के पहले के हो या तो बाद में, तो दोनों एक्ट उनको एप्लीकेबल है. तो यही मैं राहुल जी को बोलने वाला हूँ कि पब्लिक सेक्टर टेनेंट्स भी ट्रबल में है आज, क्योंकि वी आर ऑल्सो गवर्न बाय द सेम एक्ट, महाराष्ट्र रेंट कंट्रोल एक्ट. So anyway, thanks for being with us, and I hand over to Vidula ji.
I would like to introduce Mr. Maharashtra Narwekar, who is also here on the podium with us. And he has also been very actively helping us in the Kolaba constituency. And with that, I would like to give the mic to Shri Rahul, so that he can put our minds at rest.
First of all, a very good evening to everyone present here. सबका यहाँ मैं, क्योंकि ये फंक्शन, ये मीटिंग कोलाबा विधानसभा में हो रही है, तो इसलिए मैं आप सबका स्वागत भी करता हूँ. और before I express my views on this topic, I should compliment the Pugree Tenants Action Committee for taking up the initiative and organizing this event, conducting an open house where lawmakers can speak to the people who get affected by the law. Because I truly believe that in a democracy, unless there's a connect between people who make the law and the people for whom the law is made, if there isn't a connect, if there is a disconnect, then certainly the law will not be effective and it will be very difficult to implement it as well. And therefore I'm glad that you all have taken the initiative of organizing this open house where we can deliberate on this subject, where we can see how we can improvise the current provisions of law. We can see how we can protect majority of the population, in Mumbai at least, who are living under the hanging sword as to whether the Rent Control Act shall stay or not. Having said that, I must say that we have a diverse society. We have a society having different interests, and we have a society that has different priorities. There are landlords who feel they have been wronged because of the current legislation. There are tenants who feel that they have been wrong because of the threat of this protection being taken away. And therefore there are diverse views. But in a democracy, I am of the view that a decision where majority of the people stand to benefit should be honored. Because at the end of the day, in a democracy, we should ensure the well-being of everyone, and decisions in a majority are taken keeping in mind the interests of the majority and the minority, but certainly the fate of the majority cannot be compromised because handful feel deprived or feel that unjust treatment is being extended. Having said that, this issue pertaining to the Rent Control Act has been existing in Mumbai for decades and perhaps generations, where the whole background and culture of Mumbai is imbibed in the ethos that are reflected in the Rent Control Act. If you look at the history of Mumbai, which most of you all know better than what I know, who've lived in Mumbai much longer than what I have, because Pugree premises have been occupied by families for generations, for 70 years, 80 years, 100 years, 150 years. And this goes with the culture of Mumbai. Mumbai was not created overnight. Mumbai has not reached the state it is in today just in a few years. There has been a history and culture to this. And the Pugree system is a part of this culture and a part of the history of this city. The very meaning of Pugree was the honor, not honor and word only of the tenant, but the honor and word of the landlord as well, to ensure that the tenant who has been paying him rent religiously year after year, his interest is not compromised and he is not made shelterless at the whims and fancies of the landlord. So this was a bilateral promise which was given by the landlord to the tenant and the tenant to the landlord. So when people say a Pugree meant that the tenant swears upon his existence or swears upon his honor to keep his word and cooperate with the landlord, I think it wasn't unilateral, it was bilateral, because in the same breath, the landlord had also committed to his tenant to honor his word and allowing the tenant to have habitation if he is paying the due rent. And therefore, I do not think that the term pagri is restricted to the tenant alone. It is the pagri of the tenant and the pagri of the landlord which has to be recognized, which is at stake. Having said that, there are number of contentious issues which have been contested at various levels, right from the small causes court to the Supreme Court. But the matter at hand today is something that challenges the constitutional validity of a piece of legislation which decides the fate of crores of Mumbaikars and crores of residents around Maharashtra. Having said that, this is an issue which not only affects the housing problem of individuals, but this has a macro socio-economic impact on the entire society. And therefore, this issue has to be dealt with extremely seriously without jeopardizing the balance of convenience which according to me certainly lies in favor of the tenants. ये बात सच है कि इस विषय की गहराई केवल किसी एक समूह या एक व्यक्ति के ज़रूरतों के ऊपर आधारित न रहते हुए इसे अनेक लोगों की या मेजॉरिटी लोगों की ज़रूरतें को आधार में रखते हुए हमें निर्णय लेना है। जहाँ तक इस लिटिगेशन का सवाल आता है, आई वुड लाइक टू बिफोर आई इवन स्टार्ट, मैं आपको अश्योर करना चाहता हूँ कि किसी भी हालत में मुंबई के और महाराष्ट्र के टेनेंट्स के साथ कोई भी नाइंसाफ़ी नहीं होगी। फुल जस्टिस विल बी मेड and full justice will be done to the tenants of Mumbai and Maharashtra. With regards to this matter, the association has been following up with me quite regularly, and they have brought it to my notice that this litigation should be pursued very, very seriously by the state government. I have already spoken to the concerned councils. I have spoken to the department, MHADA, as well as the state government secretary housing with regards to this issue. And let me tell you, there will be no stone unturned insofar as this litigation is concerned. We shall take every precaution to ensure that we taste success in this litigation. There is no doubt that this piece of legislation, as it stood earlier when it was struck down and then was reenacted by the state government in the assembly by adopting the model code of conduct, let me tell you that there could be a scope for improvement. After all, a legislation is never temporary. A legislation improves by the day as situations change, as the requirements change, but that does not mean that it needs to be struck down. We are welcome and we are open to having suggestions and amendments to the legislation. But those amendments will have to be in consonance with the aims and objectives of this legislation. And the aims and objectives of this legislation are very, very clear. The aim and objective of this legislation is to ensure that justice is met out to the tenants, and at the same time, there is no harsh or unwarranted treatment extended to the landlords. And therefore, be rest assured, the government is seized of this issue. The government is very, very serious to resolve this issue, and we will definitely do that in the times to come. With regards to the litigation which was supposed to be heard on 9th, if I'm not wrong, on the 9th of April. So, we will ensure that all the proceedings on behalf of the state government are completed before that. May it be the written submissions or may it be any legal formality that has to be completed. I will personally follow up this matter with MHADA as well as the state authorities and ensure that your interest is not compromised and justice prevails. Insofar as the Rent Control Act is concerned, I think 3/4 of Mumbai is currently affected by the Rent Control Act. The number of residential accommodation or office premises that have been occupied by individuals are of the nature that is covered by the Rent Control Act. And therefore, if this act is struck down, one can't imagine what will be the plight of a common Mumbaikar. So, like we appreciate this hardship or perhaps this issue, I'm sure that the courts will also recognize the same. Having said that, the state government is here to ensure your well-being, and whatever may be the fate of this piece of legislation, which I don't think will be overturned, the state government will stand up for you to ensure there is enough enactment to protect you. As the Speaker of the Maharashtra Legislative Assembly, I would like to assure you that the Assembly, being the temple of democracy, which honors the expectations of the people at large, I will personally ensure that the interest of the tenants under the Rent Control Act is protected one way or the other. While I say that, I must say that I do not have any hesitation in stating that the owner of a premises should get his due. He should get his due, but it cannot be by jeopardizing the interest of the other side, which is the tenants. Therefore, a win-win situation has to be created, a situation that where both of you all stand to benefit has to be accounted for, and I'm sure that this golden balance will be achieved. We are in the process of getting some amendments. We are in the process of ensuring that this justice is met out to both the parties, and therefore I would like to request you all to have faith in the system, in the government, which will deliver your expectations. With regards to the Public Premises Act which you spoke of, the Public Premises Act has been looked upon as a draconian legislation with very limited scope for an appeal, with a summary proceeding which, to my mind, gives complete coverage to public institutions against occupants of their premises. I have personally written in this behalf to the concerned authorities that we need to relook into the Public Premises Act. We should avoid its misuse, like it was just mentioned a few minutes back, that there are a number of premises which were owned by individuals, which were taken over by public institutions, public bodies, and thereafter they were declared as being applicable to the Public Premises Act. Now certainly this piece of legislation was provided to ensure that the public interest is not compromised, that in a case where a particular premises is required urgently for any use which is going to be beneficial to the country at large, it was to be applicable only in such cases. But today we can see that Public Premises Act is being made applicable to every possible situation, and therefore there is only commercial benefits that are being looked into by these institutions while implementing, and therefore I am going to urge the government to come down heavily with regards to the misuse of the PP Act. The PP Act is certainly not a step or a means or a measure to do something which you cannot do directly, and therefore this piece of legislation has to be made effective only keeping in mind the aims and objectives which were behind enacting this law. with regards to the BPT issue, I've already spoken about that in the last meeting that we had. The matter currently is seized with the central government. We have had delegations which have visited New Delhi and had discussions in this behalf. Honorable Deputy Chief Minister Devendra Fadnavis ji himself has taken a very, very key role in ensuring that the BPT land and the tenants on the BPT land are not given a stepmotherly treatment. We have seen that when you go on P. de Mello Road, the right side of the P. de Mello Road happens to be BPT land and the left side happens to be state government or BMC land or private land. The Rent Control Act is applicable to the people on the left, but not applicable to the people on the right. So this is something which is absolutely unfair, and therefore I have urged the state government to ensure with due deliberation with the central government that the Rent Control Act is made applicable to the BPT tenants as well. And this will be just the beginning. This will be just the beginning of giving major relief to the BPT tenants. So these are three issues which I am going to work dedicatedly along with the association. Be rest assured, the fate of the litigation which is pending in the Supreme Court will be absolutely fair, and the state will put up the best fight to ensure that this legislation is not overruled. As we know, the Constitution provides for equality before the law and equal protection of the law under Article 14, and therefore I feel if Article 14 has to stand, equal protection has to be given to the tenants as well. Having said that, this is not going to be one-off gathering that we are having today. I propose to have this kind of a gathering at least once a quarter, because if we do that, we can not only resolve this issue, but we can make Mumbai effective with regards to housing. The largest problem that Mumbai faces today is perhaps housing. And when I say housing, it is not only housing of individuals who live in high-rises or in chawls, but it also includes individuals who live in shanties and slums. I'm sure that in the days to come, with this kind of a deliberation, we as lawmakers and perhaps administrators will be able to look into issues more pragmatically with your vision, which will help us enact better laws, which will help us enact laws which do not have discrepancies, which will help us enact laws which benefit not a section of the society, but the entire society at large. So once again, assuring you of my fullest support for this cause, which we shall take up at every count whenever you all need us to take this up. आप सभी लोगों को मैं आश्वासित करना चाहता हूं कि आने वाले दिनों में आपकी इस लड़ाई में हम भी शामिल हैं और सरकार भी इस कानून को कायम रखने के लिए जो जो कदम उठाने की ज़रूरत है वो सारे कदम उठाएगी और निश्चित रूप से इस कानून को किसी भी तरह ओवररूल होने नहीं देंगी. So I sincerely hope that this assurance from my end shall perhaps take away the sleepless nights which many of our residents have been facing. And having said that, let me tell you that this is an issue which is very, very dear to my heart, and this is an issue which I am also affected by, and therefore we will work strongly in this behalf, not only because I am affected, but I am affected in two ways. One, I am affected because of the tenancy issue, but the second is I am affected because you all are affected. And if you all are affected, I will get badly affected. So So be rest assured, I shall ensure that this does not prejudicially affect you, and we'll ensure that we stand successful in resolving this problem. Thank you for having me here today. Thank you for conducting this extremely important session out here. और आने वाले दिनों में हम वापस इसी विषय को लेकर मिलेंगे। 9 तारीख को जो आपकी सुनवाई होने वाली है सुप्रीम कोर्ट में, जो मुझे आपके रिप्रेजेंटेटिव्स ने यहाँ बताया है, मैं इस विषय के भी पूरी जानकारी लेकर इसमें जो आपको तकलीफ लग रही हो, जो शॉर्टफॉल्स लग रहे हो, वो सरकार की तरफ से पूरे किए जाएंगे, इसकी पूरी जिम्मेदारी लेता हूँ। बहुत बहुत धन्यवाद। जय हिंद, जय महाराष्ट्र।
I wouldn't take too much of time because I've already spoken, but after this reassuring speech from Rahul ji, there's just one thing I have to say here on a very lighter vein, that रेंट एक्ट को सुप्रीम कोर्ट के अंदर में महाराष्ट्र सरकार अच्छी चुनौती देगा, ये राहुल जी की गारंटी है। I cannot use the oratory excellence of our Prime Minister, but I think the message has gone clear that this is Rahul ji's guarantee to us, and can we take that the state government will put up the best possible fight in the Supreme Court to ensure that the Rent Act is not struck down. I'll request Vidula to Yash. If anybody has any questions for Rahul.
नमस्कार. सगळ्यांना कळलं असेल, सरांनी आपल्याला सांगितलं आहे, आश्वासन दिलं आहे की सुप्रीम कोर्टमध्ये जे काही कारवाई करायला पाहिजे महाराष्ट्र स्टेट गव्हर्नमेंटनी, ती कारवाई ते नक्कीच करतील आणि कसंही करून भाडे नियंत्रण कायदा 1999ला खालती पडता देणार नाही. तर त्यासाठी म्हणून प्लीज परत एकदा आपण श्री राहुल नार्वेकरांसाठी टाळ्या वाजवूया. आणि श्री मकरंद नार्वेकरांसाठी पण, कारण ते पण झटत आहेत आपल्यासाठी. आपल्याला क्वेश्चनाचं सेशन जर हवा असेल आता, तर मला सांगायचं आहे की प्लीज प्रश्न छोटासा असावा. 1 मिनटंभर नका बोलू, 1 सेकंदभर बोला. विचार करा काय प्रश्न विचारायचा, कारण खूप जणं आहेत आपली. आणि 1 मिनिट आणि वैयक्तिक क्वेश्चन्स असतील, पर्सनल क्वेश्चन्स, please do not air here. This should be regarding the entire community or for Rent Act itself. So please ensure that your questions are relating only to the Rent Act and what Mr. Narwekar can answer.
नार्वेकर सर, आता सध्या गिरगाव, ग्रँट रोड या साईडला मध्ये सगळे रिडेव्हलपमेंटची सगळी कामं चालू आहेत. तिकडचे ओनर्स सगळ्या इविक्शनच्या नोटीस देतात सगळ्यांना. त्या संदर्भात काय बोलू शकता तुम्ही? हां, आणि ते दादागिरी करतात, अक्षरशः सगळ्यांबरोबर दादागिरी करतायत.
जे रिडेव्हलपमेंटचे विषय आहेत, शुड आई स्पीक इन हिंदी सो एवरीवन विल अंडरस्टैंड? जो रिडेवलपमेंट के विषय है, जैसे कि आप सभी लोग जानते हो कि मुंबई में डिलैपिलेटेड बिल्डिंग्स की संख्या बहुत ज़्यादा है. विशेष करके दक्षिण मुंबई में आप देखेंगे तो फोर्ट, कुलाबा, गिरगांव, ठाकुरद्वार, चिरा बाज़ार, कालबा देवी, आपका कुंभारवाड़ा, कामाटीपुरा, फिर आपका खेतवाड़ी, ओपेरा हाउस, लैमिंगटन रोड, ये पूरा परिसर, लालबाग, शिवड़ी, परेल, वर्ली, यहाँ पे बहुत बड़े पैमाने में चॉल्स है, बिल्डिंग्स है जो 70 to 100 years पुरानी है. इनकी सिचुएशन भी बहुत ही डिलैपिलेटेड है और हर बारिश के सीज़न में कम से कम 1 दर्जन बिल्डिंग्स अलग अलग जगहों पे कोलैप्स होते हुए हमने देखी है. कुलाबा में पिछले साल 4 बिल्डिंग्स कोलैप्स हुई. ऐसे अनेक ठिकानों पर ये बिल्डिंग्स कोलैप्स हो रही है. इसका प्रिंसिपल कारण यही है कि रीडेवलपमेंट के लिए जो लैंडलॉर्ड्स है वो कंसेंट नहीं देते और कंसेंट नहीं मिलने के कारण ये प्रोजेक्ट्स आगे नहीं जा सकते। तो इसी तकलीफ को दूर करने के लिए देवेंद्र फडणवीस जी ने एक 8 विधायकों की समिति बनाई थी और उसके बाद रेंट कंट्रोल एक्ट में भी म्हाडा एक्ट में भी चेंजेस लाए और वो म्हाडा एक्ट में अभी सेक्शन 79A इंट्रोड्यूस कर दिया गया है और 79A के अंदर हम 6 महीने की नोटिस देते हैं लैंडलॉर्ड को कि ये बिल्डिंग डिलैपिलेटेड डिक्लेयर हो चुकी है, आप तुरंत इसे खुद रीडेवलप कीजिए या तो एट द लैप्स ऑफ 6 months 6 महीने होने के बाद 79B के तहत वो राइट टेनेंट्स को मिल जाता है डेवलप करने की। तो ये बहुत बड़ी प्रोविजन अभी ऐड हो गई है और इसके वजह से हमने देखा है कि मुंबई के काफ़ी जो बिल्डिंग्स हैं वहाँ पे रीडेवलपमेंट का काम शुरू हुआ है। यदि ऐसे कोई लोग हैं जिनको म्हाडा कोऑपरेट नहीं कर रही है, 79A की नोटिस सर्व करने के लिए आगे पीछे कर रहे हैं, तो आप मुझे बता दीजिए, मैं तुरंत ये 79A की नोटिस इशू करवा लूँगा।
सर आपका ये बराबर है, लेकिन हमारा प्रॉब्लम दूसरा है। टेनेंट्स लोग को ये सब ओनर्स जो है वो भाड़ा नहीं ले रहे हैं, फिर उनके पास इविक्शन का नोटिस दे रहा है उन लोग को, कोर्ट में केसेस चल रहा है।
आई थिंक ये इसके लिए कानूनी प्रावधान बहुत स्पष्ट है और ये आपका इशू पर्टेनिंग टू पोजीशन ऑफ लॉ का है। मुझे लगता है यदि कोई आपसे टेनेंट से रेंट नहीं ले रहा है तो टेनेंट शुड मेक एन अटेम्प्ट टू मेक दैट पेमेंट बाय रजिस्टर्ड एडी और बाय एनी अदर मीन्स एंड कीप एविडेंस ऑफ हिज विलिंगनेस टू पे द रेंट। बाकी you cannot be forcefully evicted because the landlord is not accepting your rent.
Sir.
Hello.
Sir.
Can you just tell us your name and from where you are?
Sir, I am from कांदिवली. एक छोटी सी रिक्वेस्ट आहे की जर टाउनमध्ये म्हाडा रिकन्स्ट्रक्शन करू शकते तर सिटी सबर्बनमध्ये का नाही काय ना 10-15 वर्ष झाले बिल्डिंग तुटून मोकळी झालेली आहे, लँडलॉर्ड काय देत नाही, रिडेव्हलपमेंट करत नाही, ट्रान्झिशन बांधायला भेटत नाही, रिकन्स्ट्रक्शन होत नाही, त्यासाठी सरकार काय करणार? नागपूर विधानसभामध्ये आमदार योगेश सागर साहेबांनी हा मुद्दा उचलला होता पण त्याबाबत काय रिक्वायरमेंट भेटली नाही।
आपका प्रश्न क्या है कि रीडेवलपमेंट नहीं हो रही है?
पगड़ी बिल्डिंग को डिमोलिश किया जाता है, उसके बाद जैसे म्हाडा यहाँ पे टाउन पे करती है,
समझा मैं।
तो सबर्बन में क्यों कोई कायदा नहीं है सर?
नहीं, बराबर है कि जो म्हाडा एक्ट के प्रोविजंस सिटी में एप्लीकेबल है वो सेम सबर्ब्स में क्यों नहीं एप्लीकेबल है? देखिए, दोनों की ज्योग्राफिक कंडीशंस भी अलग है, दोनों की पॉपुलेशंस भी अलग है, मगर काफ़ी ऐसे प्रोविजंस है म्हाडा एक्ट के जो पहले सिटी में केवल एप्लीकेबल थे, उनको अभी सबर्ब्स में भी एप्लीकेबल किया गया है। आप स्पेसिफिकली अगर कोई बताना चाहते हैं 33(7) पहले नहीं था, उसको एप्लीकेबल किया गया है अभी, ऐसे कोई अगर प्रोविजंस है जो आप चाहते हैं कि जो स्टेट सिटी में एप्लीकेबल है और वही सबर्ब्स में एप्लीकेबल हो, तो आप मुझे बता दीजिए, वी विल सर्टेनली लुक इनटू दैट।
सर 499 में क्यों नहीं मिलता है प्रोविजन? 499 में प्रोविजन क्यों नहीं मिलता है?
कहाँ सबर्ब्स में?
हाँ जी,
499 में आप कर सकते हो।
नहीं देते सर, गवर्नमेंट नहीं देती है, बीएमसी नहीं देती है।
नहीं, मुझे इसकी मालूमात लेने दीजिए, आई डू नॉट हैव।
क्या आप कांदिवली से जो हैं वो क्या आप लिखकर साहब को भेज सकेंगे प्लीज?
दे सकता हूँ।
दीजिए।
So this is Rajesh. So this is Rajesh. I'm from Kharsa. I mean, as a tenant, basically, we would just request, like the SRA is given, encroached tenants are given houses on ownership basis. Why we not given homes on ownership basis? We have tenants who have encroached on government land, like we had the policies wherein, the government says that private sector needs to take back the land, the areas which need to be occupied. You've given a lot of extra area, FSI basically, to the landlords and at cheaper prices when compared to the premiums paid on private buildings also. I mean, the premiums which are paid on tenanted buildings are lower when compared to buildings which are under societies. So here we have a sword hanging on our head day in and day out, basically. We have, we are not encroachers. We have been tenants basically for ages. And
I got your
why we not-
question. So your question is that why can't these tenancy premises be converted into ownership?
Exactly, sir.
So technically a tenancy agreement is between two private parties, which is the landlord and the tenant. But I do believe that when redevelopment happens, of late the commercial norm has been that the rehab portion is converted into ownership once
sir.
the
No, sir.
redevelopment.
Unless the premises is made into a society, we don't get our ownership back, sir. I mean, we remain as tenants, even if the owner decides to keep it as an apartment or doesn't convert it into a society, we don't get
So
ownership,
we
sir.
should introduce a provision in the DCR
Yes,
that if there is a redevelopment happening
exactly.
of a tenanted premises, then the rehab portion should be handed over as ownership
Exactly.
rather than as tenancy premises.
Yes. And sir, you are basically giving them a lot of benefits. The landlords are getting benefits of lower premiums being paid on tenanted properties. You're giving them more of FSI also. In spite of that, you know, I mean, the landlords are not giving that fungible back also to the tenants. They tell us that you get back basically only what you hold at the moment. They give us only rent. They don't allow us to take any corpus, which is our right basically because we are occupying it from years today. I mean, we have
Thank
the
you.
slums which are...
Thank you, sir, but time is very short, so there are lots of other questions.
I got your point, but this is
Thank
a
you
good
for bringing
suggestion.
up- Yeah.
Please.
We'll work around that.
Thank you for bringing up this issue.
Sir, this is my second interaction with you. The first one was in A Road. And after your speech today, I feel that I tell you all, I feel Rahul Narwekar, sir, is a person for the people, by the people, and of the people.
Thank you. Thank you.
गुड इवनिंग सर, मेरा नाम भरत सत्रा है सर। महाराष्ट्र रेंट कंट्रोल एक्ट में एक सेक्शन 56(1) भी है जिसमें टेनेंट्स को कंपेंसेशन मिलता है, लेकिन कोर्ट में जब 16G में लैंडलॉर्ड केस फाइल करता है कि उसकी पर्सनल ज़रूरियात के लिए चाहिए तब वो कुछ भी कंपेंसेशन मिलता नहीं। ये एक मेरा पॉइंट है। सेकंड, जब भी स्टैम्प ड्यूटी भरने आता है टेनेंसी चेंज होता है तब रेडी रेकनर के हिसाब से वैल्यू के हिसाब से ही उसकी वैल्यू पकड़ी जाती है। इसका मतलब उसकी पेमेंट भी वही हुई है, स्टैम्प ड्यूटी उसी के होते हैं, लेकिन फिर भी वो टेनेंट ही रहता है जबकि वो पूरी वैल्यू भर चुका है रेडी रेकनर के हिसाब से।
मुझे लगता है सेम क्वेश्चन रिपीट हो रहा है कि
नहीं, मैं थर्ड पॉइंट पे आता हूँ। उनका जो पॉइंट है ना उसमें वो लैंड कन्वेंस नहीं हुआ है, स्ट्रक्चर में वो ओनर हो चुके हैं लेकिन लैंड कन्वेंस नहीं हुआ है। अभी मेरा ये बताना है कि जब सोसाइटी होती है, मेंबर ट्रांसफ़र होते हैं ओनरशिप, तब 25,000 ये चार्ज करते हैं, लेकिन यहाँ पर लैंडलॉर्ड के ऊपर कोई सीलिंग नहीं है। 50% जो वैल्यू है उसका वो ट्रांसफ़र चार्ज लेते हैं। तो इसके ऊपर आप देख लेना।
जरूर।
We have time for only 4 more questions, please. So only those pertaining to the Rent Act.
Rahul,
And can you keep your questions and your repeat questions very short? Thanks.
राहुल नार्वेकर जी नमस्कार, मैं कपिल वोरा दादर से हूँ। हमारा रेसिडेंशियल बिल्डिंग जो है
Can we have some quiet here, please? Let the person who has the mic talk.
राहुल नार्वेकर जी नमस्कार, मैं दादर से कपिल वोरा बोल रहा हूँ। हमारा रेसिडेंशियल बिल्डिंग है, उसका लैंडलॉर्ड ऑफ हो गए हैं एंड रफली अराउंड 4 डेकेड से कोई आ नहीं रहा है रेंट कलेक्ट करने के लिए। तो रेंट कलेक्ट करने के लिए कोई लैंडलॉर्ड आ नहीं रहा है, तो हम सब टेनेंट्स मिलके एक बैंक अकाउंट में फंड्स जमा करके असेसमेंट और प्रॉपर्टी ड्यूज सब क्लियर कर रहे हैं। सो इज़ देयर एनी प्रोविजन वेयर वी कैन एक्वायर द लैंड इन आवर नेम एंड फॉर्म अ सोसाइटी?
यदि आपकी बिल्डिंग डिलैपिलेटेड घोषित की गई हो तो 79A की नोटिस तुरंत इशू हो जाएगी। यदि आपकी बिल्डिंग डिलैपिलेटेड नहीं डिक्लेयर की हो तो आपको फिर you'll have to take conveyance from the owner. but then you'll have to get that declared from the courts.
मिस्टर सॉरी पण हा वैयक्तिक क्वेश्चन झाला.
आप सभी को
प्लीज असले प्रश्न विचारू नका. कुठच्याही लॉयरकडे तुम्ही गेला तर तुम्हाला ह्याचं उत्तर कळेल. नार्वेकरांकडे आपण काय बोलायचं आहे की ह्या सुप्रीम कोर्ट मॅटरमध्ये गव्हर्नमेंटकडनं जे आश्वासन मिळालं आहे ते रिट पिटिशन्स आपले ते जे सबमिशन्स करायचे आहेत महाराष्ट्र गव्हर्नमेंटनी ते केले पाहिजेत. आपण ह्या विषयावरती आता सध्या बोलूया आणि त्यानंतर मग अजूनपर्यंत का केलं नाही सबमिशन हे खूप महत्त्वाचं आहे. पण आता सर म्हणत आहेत की ते बघतायत स्वतःहून त्याच्यामध्ये लक्ष देतील तर आपण त्यांच्या शब्दावरती जरा विश्वास ठेवूया. आणि वी आर इन टच विथ हिम सो वी विल बी कंटिन्यूइंग टू कीप इन टच विथ हिम टिल दिस मॅटर कम्स अप. So please rest assured on this because we all get affected. So anybody who has a question only on the Supreme Court case.
एक मिनट बता दूं मैं.
Farah has
मैं आपका परिचय देता हूँ. राजेंद्र ठक्कर, सोसाइटी फॉर फास्ट जस्टिस का प्रेसिडेंट हूँ. पिछले 6 वर्षों से पगड़ी वालों के लिए लड़ता आ रहा हूँ. मेरा अनुभव है कि मुंबई शहर में 50,000 लोग का प्रोटेक्शन न तो न्यायतंत्र कर रहा है और न सरकार कर रही है. 10-10 साल तक लोगों को न भाड़ा मिलता है न घर मिलता है. हाई कोर्ट का ऑर्डर बहुत अच्छा आया. मैं एक बात से सहमत हूँ कि रिकंस्ट्रक्शन और रीडेवलपमेंट इसमें कोई संदेह नहीं. लेकिन साथ में हमने सभी एमपी 6 एमपी हैं मुंबई के, 36 एमएलए हैं, सभी को मैंने लिखकर भेजा है सोसाइटी फास्ट जस्टिस की तरफ से कि जनता की रक्षा का काम या तो न्यायतंत्र करेगी और हमारा न्यायतंत्र जिसमें 5 करोड़ केस बाकी है वो आप किसी की रक्षा कभी भी नहीं कर पाएगी. केस करते रहिए, एडवोकेट को पैसा देते रहिए, आपको कुछ मिलने वाला नहीं है. और ये मेरा अनुभव है. दूसरी बात, आज की तारीख में चुने हुए प्रतिनिधि खुद बिल्डर के साथ मिले हुए हैं. मैं आपको क्लियर बोलता हूं कि जब तक आप लोग अपना कानून नहीं बनाएंगे, सरल कानून नहीं करेंगे, तब तक समझ लीजिए मैंने एक प्रस्ताव भी रखा है.
सर
फरवरी जी से अच्छी तरह जानता हूं.
सर सॉरी बट दिस इज नॉट द प्लेस.
अभी आप रोकेंगे ना. ठीक है, कंप्लीट करिए, जल्दी करिए. एक बात जरा सुनिए. और मैं 6 साल से लड़ रहा हूं. मेरे पास 2000 लोगों का डाटा है. 3 समस्याएं हैं. पहली समस्या ये है कि चाहे वो बीएमसी की जगह हो, महाड़ा की घर हो, सेस का हो, नॉन सेस का हो, तोड़ने के बाद सरकार ने कभी भी उसको आगे नहीं बढ़ाया. चंदन बीटी चाल जो है वो सबसे बड़ा उदाहरण है जहां पर बिल्डर ने बिना दिए लोन भी ले लिया. दूसरी बात कीजिए, जिन लोगों ने भाड़ा लिया, जिन लोगों ने लोन लिया है, आज मेरे पास 75 बिल्डर का लिस्ट है. लिस्ट मैंने सभी एमपी को भेजा है, सभी एमएलए को भेजा है, प्राइम मिनिस्टर को भेजा है और जज को लिखा है कि आप ताला मार दीजिए सुप्रीम कोर्ट के जज को कि अगर आप न्याय नहीं कर सकते हैं 50,000 1 लाख लोगों से तो ऐसे न्यायतंत्र की इस देश को जरूरत नहीं है, आप ताला मार दीजिए. ये मैंने लिख कर भेजा है, सिर्फ बोला नहीं है. और आज भी बताता हूँ, ये इतना बड़ा गलत है कि हमारे चुने हुए प्रतिनिधि ही बिल्डर के साथ मिले हुए हैं. और मैंने लिख कर भेजा है जज को. चंडाल चौकड़ी में सबसे पहला नाम बिल्डर का, दूसरा सभी चुने हुए प्रतिनिधि का, तीसरा जज का और चौथा हमारे देश के अंदर सरकारी अधिकारियों का है. ये 4 ने मिलकर आज 3 लाख लोगों को बेघर कर दिया है. अगर आप एक नहीं होंगे, इस तरह के मीटिंग से समस्या कभी समाप्त नहीं हो. ऐसा मेरी बात को बुरा मत मानिएगा. मैं चाहता हूं, मैंने 7 प्रस्ताव रखे. सुनिए, मैंने 7 प्रस्ताव भेजे.
सर
समाधान हो सकता है.
सर
बिल्डर के लिए ऑर्डिनेंस हो सकता है.
सॉरी प्लीज 1 मिनिटापेक्षा जास्त वापरू नये वेळ म्हणून मी म्हटलं होतं. तुम्ही खूपच जास्त बोललात आणि विषयाला धरून पण बोलला नाही.
हेलो सर, मैं धर्मेंद्र व्यास बोल रहा हूँ घाटकोपर से. अभी आपने कब बताया 337A का जो अंडर सेक्शन रूल्स का, लेकिन उसमें जितने भी बेनिफिट है वो किसी भी भाड़ूत को नहीं मिल रहे हैं. प्लस अगर भाड़ूत खुद बनाने जा रहा है तो उसको लोन भी नहीं मिल रहा है. तो इसके लिए क्या करेंगे वो, क्योंकि उतना पैसा भाड़ूत कहाँ से लाएंगे?
देखिए 79A के अंडर ये प्रोविजन डाली गई है ताकि जो लैंडलॉर्ड्स विलफुली कोऑपरेट नहीं कर रहे हैं रीडेवलपमेंट के लिए, उनके ऊपर चेक लाया जाए.
Okay.
यानी वो अगर 6 महीने में नहीं कर पाते हैं तो टेनेंट्स को ऑप्शन मिल जाता है दूसरा डेवलपर लाने के लिए या खुद डेवलप करने के लिए, ऑप्शन है आपके पास. सो आई थिंक ये शुरुआत बहुत अच्छी है और इससे काफ़ी राहत मिल रही है काफ़ी टेनेंट्स को. लेकिन इसमें अगर और संशोधन करके और इम्प्रूवमेंट लाने की ज़रूरत है तो द गवर्नमेंट विल बी ओपन फॉर दैट. देयर इज नो डिफिकल्टी.
मैं वही कहना कि अगर भाड़ूत को उसमें लोन मिल जावे.
देखिए ये सब इश्यूज है ना, ये कमर्शियल इश्यूज है.
हाँ.
यू विल हैव टू.
One last question.
Yeah, I'm Rajesh from Pedder Road. Thank you very much for giving us this assurance that this matter will be addressed by the court. But the fact of the matter is, sir, that the state was supposed to file this matter in December, and it was supposed to come on board in February, but it didn't. Had it come up on board and the state hadn't done it, now what is the reassurance that you're giving that it's coming on April 9th, that you will abide by the law and ensure that your state takes it up? How can you give us? You've told us very nicely that yes, you will take it up, but...
No, in fact, I have already had, in this behalf, when the delegation had come to see me at Vidhan Bhavan, I spoke to the housing secretary myself, I spoke to the VP Mahada, and I also happened to speak to the counsel on record in Supreme Court who's dealing with this matter, and they have all assured me that all the legal formalities and submissions will be made before the date of hearing.
So I would just request that if the action committee that is there, if they are abreast of the situation on a day-to-day basis, then they are informing us. So since this matter is so grave, if we are assured that yes, this will be taken up, I'm sure the court will take care. Thank you.
Definitely.
Hello,
I think that was the last.
my name is Farah. The
Yes.
government is for the people, by the people and of the people, right? Okay? Huh? So
Yes.
the thing is, now, you said 9th April, the government took decision to give some answers to the tenants, right?
No, 9th is the date of the hearing.
9th April, right? So why they had to take the decision and to take it forward only? They shouldn't have. They should have disqualified in that time only. Can
No,
you
no.
papa- For the tenant, we are not going
The
to do like
government
this.
the government is standing to ensure that this law is not overruled. So the government has made the law. It was challenged by perhaps the landlords. They won in the lower judiciary. There's an appeal filed in the Supreme Court. So the government is doing its bit to ensure that this law remains and it is not overruled.
And there should be something for the tenants, because there are so many tenants who will be,
Yes, yes.
And there are so many buildings who are broken
Yes,
down and
yes.
they are not being built. And they are all on the road. Children are displaced from schools and they don't
Farah.
have money and...
Farah,
Yeah.
I think. Thanks. Okay.
But what I would request is, yes, those who have any particular suggestions, what I would request you to do is, I will give you my email address. If you all can email. Yes, yes. So the email address will be circulated on the chat of the action committee. SPEAKER rsn1@gmail.com.
I will take this email address from sir, and I will post it on all the groups. So give us some time. We shall do this. आणि आता खूपच उशीर झाला आहे. I request everybody who is not on the chat groups and would like to join, don't forget to fill in the slips that we had given earlier. Those of you who have not done it, can you please redo it? And I would like to now propose a vote of thanks. No, wait. Yash, please.
Can we request everybody to just be a little quiet? We want to thank sir, please. Sir, please, there will be 10 more people. There will be 10 more people, sir. We will have another gathering where you will be able. There will be There will be. You will get a chance. You will get a chance.
मॅडम मॅडम सगळ्यांचे प्रॉब्लेम्स आहेत मॅडम
Can we request everyone, please?
सो 1 मिनिट वी आर हिअर टुडे आम्ही आज इकडे आलो आहोत सुप्रीम कोर्टच्या मॅटरसाठी ह्याच्यासाठी आपण परत एकदा एक करूया ऑर्गनाईज आणखी आणि तेव्हा तुमचे सगळे प्रश्न जे आहेत ते तुम्ही आधी द्या म्हणजे सरांकडे उत्तरं असतील आता प्लीज तुम्ही ह्या विषयांवरती वैयक्तिक विषयांवरती बोलू नका कारण आपल्याला सुप्रीम कोर्टचा मामला खूप जास्त मोठा आहे तो नसला जर सुप्रीम कोर्टमध्ये आपण हरलो तर आपण सगळंच हरू सो प्लीज आज तेवढंच पुरे आणि वी वुड लाईक टू प्रपोज अ वोट ऑफ थँक्स जरा 5 मिनटं बसाल का तुम्ही प्लीज
We'd like to, can we please have decorum for 2 minutes for a vote of thanks to thank Mr. Narwekar. May I request everybody please maintain decorum.
सब लोग
for
प्लीज
2
5
minutes.
मिनट बैठ जाएंगे प्लीज
2 minutes.
आप लोगों अगर हमें इस तरीके की मीटिंग्स और रखनी है और अगर हम इस तरह से बिहेव करेंगे तो शायद हमारे लिए डिफिकल्टी होगी सब लोग 5 मिनट बैठ जाइए और यश जी जो लोगों ने ये प्रोग्राम ऑर्गेनाइज किया है उनको धन्यवाद करना चाहते हैं आप उनके लिए रिस्पेक्ट के तौर पे 5 मिनट बैठ जाइए इट वुड बी हाईली अप्रिशिएटेड
Thank you, Prerak. We'd like to thank Mr. Narwekar, the Honorable Speaker, for taking time out of his busy schedule to meet us. I think hearing him today has reassured all tenants that the state of Maharashtra is with us and will protect tenants. I'd like to request Reshma to present a small token of thanks. We would also like to thank Mr. Maharashtra Narwekar, who has for the last 10 years stood with us and has always given us a year. I'd like to thank Vidula, Reshma, Mr. Sapre, Prerak for taking time out, for putting in a lot of effort for this. And we'd like to thank all of you for coming and for showing Mr. Narwekar that we are there in large numbers and that this is an important issue. And thank you all for taking time out of your schedule. For anyone with personal questions in their particular matters, Prerak and I are both advocates. We will wait here afterwards. We will talk to all of you. We can let Mr. Narwekar, we don't need to trouble Mr. Narwekar with that.
Has any personal questions, Yash and I am there to answer it. Please do not take up personal issues with Honorable Speaker, sir. Leave his time for the constitutional issues to be taken.